there can be no disagreement on this issue.
Well, what I'm saying is this is settled law.
Right.
So that's what I'm saying. Yeah, right. If he disagrees with the court's own settled law, then there's a problem with that as well. I mean, it just doesn't.
Do
Again,
you take the position that the SJC can change or modify an existing law?
the SJC cannot do that. The creation of the law under our Constitution is the exclusive domain of the legislature. And if the SJC takes it upon itself to rewrite the law, they have violated the separation of powers clause of our Constitution. That's what the whole independent judiciary is all about.
Yeah, but they've done that in other cases. They changed the law with regard to gay marriage.
Well, that's different. That's not those you know that's something that they did as part of the evolving of the common law. But this is when the legislature makes a statute and they say this is what the law is. That is what the law is.
And the Supreme Court can never change.
They cannot. If the language of the statute is plain, in other words, there is in Massachusetts law. There's actually a statutory standard for the interpretation of so-called construction laws, and I mentioned that in my testimony as well. And that is that laws shall be construed according to the common and approved usage of the language. It's the language, the law is the language. I mean, if we can say something really simply in plain language, and none of us can agree on it, then nobody would ever know what the law is. Nobody would ever know
What
what
I'm
it
getting
is.
at is the SJC always, over the years, has taken laws and either tweaked them or changed them or found them to be
Well,
unconstitutional.
let me read you the law.
No, I know
You
that.
read what it says, and you tell me what you think
My
it says.
question is different. My question is, you're saying they have no right to have any other definition of that law other than
Well,
what you're saying?
I'll read to you the law, and you tell me what you think.
I know. It's
Right.
not what I think. It's
Okay.
what the SJC thinks. Lawyers go up there all the time, and they both have different opinions.
Right.
One of them leaves not getting their way.
Well, again, if I may, I can read you the law. And
You're trying to convince us that the law is right. We are not the Supreme Court.
right, but I mean, if the legislature passes a law, and I read it, and it says, any person may institute and prosecute a civil action for treble damages for any loss of wages. Do I have to wait for the SJC to tell me what that means?
You don't. But sometimes those wordings are challenged by somebody in the up at the SJC.
Sure.
And they say, we're gonna set a new rule here.
Right. But the
And
rule,
you say they don't have any right to do that.
well, the thing is, when you say a rule, what the rule is,
To answer my question, what? Are you saying they don't have any right to change it?
right, what I'm saying is that they did not have the right to engraft onto the statute the provision that a plaintiff would have to prove outrageous conduct, evil motive, or reckless indifference. That was the sole domain of the legislature to decide. And that is acknowledged in their own case law.
Okay.
That's what I'm saying.
I'm going to be interested to see what the judge has to say about that. And if you can, come back next week. I would appreciate it.
I would
Because I'd like
happy
to
to.
have you listen to his answer.
I will look forward to it.
And I'm going to ask the questions you sent to me of the judge, and we'll see what his public answer is.
Yes.
Not being a constitutional scholar of the law, we're going to leave it up to the judge to answer the questions, and then we'll see where it is.
Great, I appreciate that.
Hi.
Yes.
Are you your attorney?
No.
Okay. How long have you known the nominee?
Have I known?
Have you known the nominee at all?
I-
Have you had any dealings with the nominee prior to this document?
No.
Have you ever had the opportunity to discuss this document with any attorney?
The document, when you say this document, the document I sent,
This,
Council Jubenville.
no, I got the document from Jubenville about 5 minutes ago. This document, this book.
Right. This book is I just put together this book.
Let's put it together.
But I again, the document that these documents are based on, I sent to the legislature. I put that together a while ago.
Your whole intent, in 3 sentences to 5 sentences, 2 minutes. What's your whole intent of producing this document?
Well, that document was to provide evidence in support of my,
Excuse me, sir, we want to get one too.
Oh, sorry.
that document is to provide documentation in support of my testimony. It's to provide evidence in support of what I am saying to you today.
When did you start preparing this document?
I started doing it, well, actually putting together all the documents. I had them around because I wrote that other document about a year ago. So it took me about a week to put this together, but, well, almost 2 weeks actually.
Okay, you have to, can you narrow it down for me, please?
Sure.
What is your purpose of preparing this document?
My purpose,
Besides coming here to speak in opposition of the nominee, what's your purpose?
Yeah, if
Because the
you
nominee
want-
is not the only person that's responsible
yes.
for this, so go ahead.
Right. Well, if you would like, if the council would like, I can take you through this documentation right here and now.
What I'd like you to do, and it is possible, I'd like you to prepare it in text format, email format.
And that's what
we'll
I'll
discuss it.
I'll
We'll have
send
that
you.
as part of
Yes, sir.
your continuation next week.
Okay, I will do that.
Thank you. Councilor Aguilar.
Yeah, I'll be brief. Who do you work for, sir?
I'm doing something on your behalf.
I just need,
Well-
like, I have your name, but I'm just curious.
So I'm sure the question points to why do I know about this.
And I just asked, sir, who's your employer? Are you self-employed?
I'm self-employed right now.
And what line of business are you in?
I'm working on, I used to work in sales in the contract industry.
I'm sorry, sales, what we say, high
In the
tech?
IT industry.
The what?
IT.
I take,
Yes.
And is that where you work now?
No.
So you want, I'm just want to get a sense.
Well, I guess I'm technically unemployed right now.
So you're unemployed?
Yeah, that's right.
Okay, these cases that you referred to, with respect to the trouble damage issues, you're not involved in these?
I was. That's how I know about it.
I'm sorry?
I was, and that's how I know
What
about
case
it.
were you involved?
It's called Okerman versus VA Software. Okay. O-K-E-R-M-A-N. Versus VA Software Corporation.
Was that an issue again with trouble damages? and
Yes, it was for commissions which are covered by the wage act and the trouble damages.
Okay, and obviously, the case went all the way to the SJC?
No, it did not. It went to the appeals court.
Okay, and I assume they ruled against you?
No, actually they didn't.
So who appealed, before it went to the appeals court, the Superior Court?
What happened was I brought a claim under the Wage Act for unpaid commissions. My
Where did
claim
you
was
bring this one?
in Superior Court.
Okay.
My claim was dismissed right at the very beginning under what's called Rule 12b-6. It's a civil procedure. And so the dismissal eventually made it to the appeals court, and the appeals court actually reversed the dismissal and reinstated my Wage Act claims. But between the time that I filed the case, at the time I filed the case, all of the available, even the available case law said that trouble damages were mandatory, aside from what the 2900 statute says. And so after the appeals court ruled, the company capitulated and paid.
Okay, and you've never had any cases at the SJC, is that right?
I have not.
You have not?
I have not had cases in HSC.
Never. So you've never, have you had any cases in the Superior Court in front of Judge Dean?
No,
Okay, so you've never appeared before Judge Dean?
I have not.
Okay. And I understand your issue is not specifically against Judge Gant, it's really against the entire SJC. I thought you said that you managed.
That's absolutely correct.
Okay.
Yeah, he's one of 7, as we heard earlier. He's
So
one of
your
7.
proposition, if they were all, Councilor Jubal talked about a review process. I know we talked about the Chief Justice, but if there was a review process for all members of the SJC for every 2, 3, 4, you'd probably be here against all
Well, in this, based upon
Because
this
this
case, absolutely.
That's fine.
Yes, yes, sir.
of them. I don't have any further questions.
Okay.
Madam
have another one?
Yes, just one last one. So
Councilor Lee.
you mentioned a little while ago that you just had a bunch of documents hanging around and you put them together. But you do have a selfish reason for preparing this document.
And what's that?
Selfish reason for preparing a document is that you want to have due process in resolving your issue with your settlement in this case.
My case is over.
There's no causality between what you had happen before and this document.
The reason I know about this is because of my case. That's why. I mean, I would probably it'd be unlikely I know about it.
So there is a causality. There is.
Oh, sure. That's how I know
That's
about
the
it.
question that's
Yes.
what I asked you. I asked you why you created a document.
Yeah, because when I realized when I had done, the research into the case law and into the history of the statute, I realized that this was a monumental error and that I had been affected by it, like many other people. So, it's, I could have just taken my money and just moved on, but I didn't do it. I couldn't do it.
Thank you very much for your testimony. The next person to testify in opposition is Jackson McKay.
Good afternoon. I was wondering, Madam Chair, some comments have been made about Section 8 of the hearing and that it would be next week. I'm wondering if you could clarify that because I was
Well, I didn't have a crystal ball when I came in here. I didn't know how long this would be, and Judge Dan was patiently waiting. He has 10 o'clock, and so I have you and Joe. You're going to testify, and would you please do that? So that we
well, I was just I had initially heard that there was going to be a hearing tomorrow, but now I get the feeling it's going to be next Wednesday. If you could share with us that would be a great help to me.
I would like to have it tomorrow, but we have lawyers on the council and so forth, so it isn't suitable. So if I do, the way it's going now, I probably have to. It'll be next Wednesday.
Okay, that's great. I appreciate that.
And I have to book this on for.
Okay. My name is Patrick McCabe. I live in Hyde Park, Massachusetts. And my opposition to this nominee, I don't think comes as a surprise to anyone. We reached out to the governor and urged him not to make this nomination. We also urged him not to nominate any member of the SJC who was a party to the Adams decision, and that is the reason why I'm here to speak out against this nominee. The Adams decision. And that would include everybody except for the most two recent additions, which would be Judge Duffley and Judge Lane. The Adams decision was a decision that we've actually, an issue we've been talking about for some time, and that is how does a parent, a capable and fit parent, lose custody of their children? And Mr. Adams presented that very issue as part of his case to the SJC. And prior to that decision being made, for those who were present, you had an earlier hearing for the former Chief Justice, and we urged him, if this issue ever came to the SJC, just please answer how a parent loses custody. And we really think the way to move this issue forward, because as you know, most in a divorce, either one parent or the other parent loses custody, seldom is shared custody, and that really is not our law. So we asked them just to, if someone does lose custody, explain why they lost custody of their children. Unfortunately, in the Adams case, they did what seems to happen so many times. They acknowledged the issue. They chose not to answer, but went on to explain that one parent got custody. And again, if they wanted to say that one parent lost custody and say, here are the reasons why, that would move us forward. We would have something to discuss and something to move forward with. In my opinion, and I've stated this on many occasions, I think this opinion was completely disrespectful to all the families in Massachusetts. But I also want to point out, because of this particular case, it's particularly horrendous. Mr. Adams was an incredibly wealthy individual. He was very well represented. He had Harvard lawyers presenting his case. If he cannot get the SJC to answer a matter of law and instead just be ignored, what chance does anyone else have? Now, as you know, I'm the co-chair of the Fatherhood Coalition. We deal with these issues all the time. We never advise anyone to try and take a case to the SJC. We feel that the current leadership is completely biased against families, particularly on this issue of custody. This is why I'm speaking out against Justice Gant, because I don't think he is the person to take the court in the right direction, which is to start addressing these things, to start properly addressing these family issues. Our laws changed some 35 years ago. We still have not come to a realization of our new laws, which is basically no-fault divorce. Those are the terms I believe they use in Massachusetts. That is the concept. Our courts still treat both parents as one parent is a winner, one parent is a loser. That is not our law. That is their practice. These cases seldom come to the SJC, and I acknowledge that at the last Chief Justice hearing. So I don't know if another case is going to come up again. I'm not suggesting that anyone take a case like this to the SJC, but they have put a huge roadblock with this Adams decision from just a few years ago. There are one or two other issues that have come up that I feel necessary to address Mr. Gantz about, or Justice Gantz about, and one is the support of the Justice Program. There are some parts of that program that I absolutely love. The lawyer for the day, when I talk to people, I am always referring people to the lawyer for the day. It is a great program, it is a great resource. However, there is another aspect that I've complained about before, and that is when you have indigent parties coming into divorce. You have two people without lawyers. There are programs that will give one party a lawyer. As I have said before, when I appear at those hearings, they are the nastiest hearings I have ever seen. These independent lawyers who are not being paid by their clients are the biggest bullies I have ever seen in family court. And I really think, if from a management point of view, if you're running that program, you would want to have both parties getting lawyers. That is not what is going on right now. I think from a management point of view, setting up a program like that is a mistake. And I would hope that if you want to move it forward where people are going to be represented, that you represent both parties and not simply one party. Finally, there is an issue that has been in the papers that I think is very concerning for the whole SJC right now, and that is the Justina Pelletier case. Justina Pelletier was a resident of Connecticut. She went to Children's Hospital. Children's Hospital was concerned about child abuse, reported that to DCF. DCF found that case. Justina Pelletier was a resident of Connecticut. How that case ever got into a Massachusetts court, I don't understand. Why it was allowed to stay in a Massachusetts court, I still don't understand. Why when it became public, the head of our courts didn't straighten that thing out and take it over to Connecticut is still beyond me. I think it's inappropriate at this time to reward any member of the SJC while it appears they are not doing their job on that case. I think, as far as I know, I have yet to hear someone disagree with me. That case has always belonged in Connecticut. A judge here in Massachusetts made an error, and the SJC has not done their job by correcting that error.
Okay, so what you're testifying to, Jaffrey, is related to Justice Gantz and the opinions that he has given when you talk about someone being controlled with children and not getting custody?
In the Adams decision, Justice Gantz did not write that decision, but he did not write a different opinion either. Had he written an opinion stating why he thought one parent should lose custody or not lose custody, I would have a different opinion. Absolutely. If the Justina Pelletier case If the Justina Pelletier case had been resolved at this point, I wouldn't be bringing that up either. In fact, I understand the governor did everything he could to try and get the Justina Pelletier case out of Massachusetts by having the child moved to Connecticut. But the SJC still has not done their job. And that does remind me of one other thing. I like the idea of people being represented by counsel, but I don't always hear another term that goes with that, and that is competent counsel. Oftentimes people get a lawyer and there's this idea that they're properly represented. That is not always the case, particularly in the Justina Pelletier case, where they, as being litigants in a juvenile court matter, they were given counsel. It does not appear that that counsel, which was provided by the state, properly represented those people, and in fact created this whole nightmare that you now see. So, quite honestly, I've read a lot of what Justice Gantz has to say about providing people with counsel, and at least in one publication, he did mention competent counsel, so, and I would congratulate him for that, but I don't think that term competent counsel is used often enough when we're talking about giving people counsel.
Okay, first let me say that all of those points that you made out, made today, I'm sure that Justice Gant will address those. One thing that I was going to ask Judge Gant, and obviously I'm not going to get to what Judge Gant doesn't give me a lot to speak yet, but I have a question about custody. And when custody case comes from the probate court and it goes to the SJC, is Judge Gant given the facts, or does he have to just look at the law? And so, you know, is he given all the facts and the anguish of that child and given to one parent, not the other, or what the injustice or the justice of it? I don't know, and that's what I would. You said that. That's a question I want to ask because I don't know that, and so all of this will be answered by Justice Gant when he's allowed to make a presentation, because I don't know that. I want to know, does Judge Gant have discretion to exercise when that case comes from probate, to look into it and get all those facts, or does he have to just follow the rule of law?
Well, again, in the Adams case, the question was, as married parents, they both had joint physical custody. Physical custody was taken away from one parent. That was the issue put before the court. And of course, he does have authority to review it, even if he wants to support affirm the earlier finding. But generally, when you read decisions, they will state what the issue is and how they made their decision. What we saw in the Adams case, what we so often see in custody cases, they just ignore it and they say this parent got custody. They're simply not doing their job.
Let me just say that with all your testimony, I'm sure that Justice Gant is taking notes and is going to address that. And so the counsel won't be answering those questions. Those will be directed to Judge Gant, and he will make note of your testimony. But I don't know if anyone else has any questions.
I just have one question.
Justice Gant.
Pelletier case, did you look into that at all?
As far as
jurisdiction?
as far as I know, it goes under the Uniform Child Act, which means, you know, where is the residence? She lives in Connecticut. The parents lived in Connecticut. You know, all this argument about whether she should have been held, that's a different issue. I have been involved in a number of cases where we do have cross jurisdiction between different states. I've been involved in cases that go from Worcester to Hartford. I've been involved in cases that go from Providence to the southern part of Massachusetts. These types of cases that go across jurisdiction are not unusual, and they always go by the resident of the child, with the exception of the Pelletier case.
Well, I will try to look into that, because usually the courts don't take a case unless they have pretty firm jurisdiction in the matter.
I'm agreeing with you completely.
In fact, it's been my belief that courts, if they don't have jurisdiction, can't wait to get rid of the case. So
Yes.
it's here for a reason. Some judge has made a decision, there's jurisdiction here to hold it.
They could be a mistake.
It could be, but the lawyers, if that were the case, I would suggest it would have taken that up to 11-3 appeal or something to get it out of Massachusetts if they thought there was a mistake.
From the prosecuting side, because from the defense side, it appeared that the lawyers that they had was not a very good one.
I'm going to see what
Any other counsels have any questions? Well, thank you very much, Catherine. The last to speak in opposition is Joe Young. Just hold on 1 minute until we get you paid.
Good afternoon, councilors, and thanks for the opportunity to speak with you again. For the benefit of the audience, welcome to council, because I've spoken before you on several occasions over the last 3, 4, 5 years. My name is Joe Uranic, and I'm the chair of the Fatherhood Coalition. Patrick, who just spoke, is the vice chair. So, just to begin, I was at the council hearing in 2009 when Justice Gans was appointed to the SJC. I did not speak, we did not speak at that hearing, but I did take a video and I was viewing some of the footage recently, and there was one particular part of the video that I wanted to bring to your attention, which is Justice Gans is quoted as saying, as a trial judge, we help parties resolve their issues. Now, I can tell you in the probate court, at least, that is really not what happens for the probate courts. The courts are really a destructive force in the lives of people that come before it. And so I think that statement is not really accurate as far as the probate and family courts are concerned. Another quote in from Justice Gans in that hearing is the Constitution must be seen in its historical context. Now, I agree with that statement completely. But he goes on to say, but it is a living document and must adapt. And so, from my perspective, those kind of statements indicate somebody who is willing to really change what is written. And this goes to the gentleman who was just speaking a few moments before on the wager cases, where he said words have plain meanings, but this kind of attitude about having a living and breathing document, the words that have plain meanings have other meanings grafted onto them in place of their original meaning, which would go to his first statement about the Constitution should be seen in its historical context. So I think those kind of that kind of perspective on the law and the Constitution, from my perspective, is very concerning and not something that I would agree with, and hope that the council would take look at that and question that the Justice Gans when they have the opportunity. The second point, there are 4 points I'm going to make. The second point is, in addition to adding to what Pat said about the Justice Dean of Pelletier case, there's a very large group of people in the public right now who are very upset at what happened to Justine Pelletier. Now, the courts certainly have not really done much to delay the fears of the ordinary citizen out there. And from what I see, the SJC and Justice Gans, as a part of the SJC, should have asked to review that case and to deal with it in some way. As Pat mentioned, Justine was a Connecticut resident, and she was basically taken away from her parents because of the diagnosis or analysis of one particular person at Boston City Hospital. And then she was kept in a block psychiatric ward for some 8, 9, 10 months against the wishes of the parents because of its dispute between Tufts University and Boston Children's Hospital. And then this force on taking the child was basically stamped the approval of the juvenile court judge, Judge Johnson. So it's something that should have been dealt with, in my opinion, by a number of different actors in the government, including the Supreme Judicial Court. It was not. I think it's something that you should inquire of the justice when you have a chance to ask the question. The third point I'd like to make, and probably the most noteworthy, is Justice Gans did author a case, the decision in the case, McDonald versus Caruso. And this came out just in March of 2014. McDonald versus Caruso. And it basically talked about the Caruso had wanted to vacate a permanent restraining order. And there were a number of arguments made for the reason for vacating it, including the fact that the person had not been in any contact with the original plaintiff for a number of years. That he lived 2,100 miles apart from the plaintiff, that he had remarried, and those were the main sort of substantive reasons that he thought that it should be vacated and that it should not be continued. One of the reasons he gave was it did take away his right to own a firearm. That's what happens under the 209A restraining orders. People cannot purchase firearms anywhere in the country. And so some of the reasoning I found given by Justice Stevens, who authored that, was, from my way of thinking, was a bit odd and strange and really should be questioned. And so he does state in his writings that the reason for the 209 restraining order is that there should be a fear of imminent serious physical harm. But aside from the fact that there should be this imminent fear of physical harm, you have this plaintiff who lives 2,100 miles away, who has remarried and has a totally sort of separate and stable, apparently stable lifestyle, as different from as distinct from when the person was in this contestation with the plaintiff some years before. In New York City, in New York originally, and then later the 209A was issued in Massachusetts. So there's this idea that from our way of thinking, the idea that the 209 restraining order is something that should be extended even when there is no reason to extend it strikes us as wrong. And so I hope the council will look at that. Sure.
Yes, Council. Council Kennedy.
I haven't read that case recently, but I read it when it came out. And I say this respectfully, my recollection of that case is a little different. It may be misreading the point. I think what that case did was establish what the burden would be for vacating a lifetime restraining order. My recollection was that that case said that the burden didn't say that it shouldn't be vacated. It didn't say that that there were no circumstances under which it would. I believe what it said was, and I don't necessarily agree that it should be that burden, but it said that the burden was on the defendant in the restraining order case to show by clear and convincing evidence that he's not a danger. That's what I think the whole.
You're absolutely correct. That was the end conclusion.
Well, I think that was what the holding was in that case, not that with the particular facts of that case. I mean, the SJC is not deciding the case. Some judge in the lower court is presumably the district court would be, or probate court. And what the SJC was doing in that case was laying out what the burden would be for the lower court judge in deciding whether to vacate, as opposed to, putting it on Judge Gaines that this person's 2,100 miles away and all this other stuff. That's stuff for the trial judge or the hearing judge in this case to weigh in terms of whether they need that burden.
Well, I agree with if I may, I agree with your first statement that was the essence of the decision. But the fact of being 2,100 miles away and being married, according to the decision, was not sufficient enough evidence to vacate the order.
Well, I think that what it said was that they upheld the trial court that wasn't enough to vacate the order applying that burden.
Right, that's true. But in addition to that, I think you're absolutely right, and we may not be disagreeing at all on this. But I would say further insult to injury, if I may use the expression, was the further statements by Justice Hanson in his decision, is that he laid out a whole series of steps that the person should have taken to prove that he was not going to be further danger to the original plaintiff. Now, remember, the original 298 order is imminent physical harm. Now, clearly, if someone's 2,100 miles away and they're married, they're not going to be imminent serious physical harm.
He's not the trial of fact at that point.
My point is that in addition to that fact, the fact is he's saying that's not sufficient. That's not sufficient reasons to vacate the order. But in addition to saying that those two substantive issues are not sufficient, he's also saying that the defendant should have done a number of different things. Now, I'll read them here if I may. It says the defendant did not submit an affidavit to the chief of police or the keeper of the records of the city in Utah, attesting that the police had no record of any allegations of domestic abuse, or submit the New York and Utah equivalent of the Massachusetts Criminal Offender Record Information, CORI, and statewide registry of civil restraining order records to show the absence of arrest or convictions of other restraining orders. To prove that he had truly moved on with his life, the defendant in this case needed to demonstrate not only that he had moved on to another